yan para matanggal si VP Sara sa kanyang pwesto, ang kanyang pagtataksil sa tiwala ng publiko o betrayal of public trust. To refresh, Madam Chair, ayon sa Korte Suprema, sa Gonzales, the third verse of the President, ang betrayal of public trust ay maituturing na gross faithlessness against public trust, tyrannical abuse of power, inexcol, negligence of duty, favoritism, gross exercise of discretionary powers, at iba pa. Mga gawain na nakakayurap sa interes ng publiko at nakakasira sa reputasyon ng opisina. Madam Chair, sa nagdaang mga buwan at taon, mula pa noong 19th Congress hanggang ngayon, it has remained clear to us that Vice President Sara Duterte betrayed public trust, and for that reason, the people are once more charging her with same through this impeachment complaint. Ano-ano mga ginawa niya na may tuturing na betrayal of public trust? Madam Chair, 3 po ang nakita nating mga kagawan or 3 acts. Now, to summarize just very briefly, number 1, inabuso ni VP Sara Duterte ang kabuuang halaga ng 612.5 million pesos of confidential funds sa OVP at sa Department of Education mula noong 2022 hanggang 2023. Breaking it down, that's 125 million pesos in 11 days back in December of 2022, and another 375 million pesos in the OVP and 112.5 million pesos in the Department of Education in 2023. Hindi pa rin nasasagot hanggang ngayon kung paano ginastos ang pondong ito, na kahit confidential in nature ay questionable o kaduda-duda pa rin sa pamantayan ng gobyerno. Pangalawa, kaugnay sa pagiging kaduda-duda, isiniwalang bahala din ni VP Sara Duterte ang mga prinsipyo ng transparency and accountability dahil direkta niya may mga inutos sa kanyang mga tauhan ang paggawa ng mga gawa-gawang dokumento at accomplishment reports kuno para pagmukhaing may kinatutunguhan ang limpak na pondo na nilaan sa kanyang opisina. Dito natin natimbog ang mga katulad ni Mary Grace Piatos at iba pang peking pangalan na tumanggap umano ng confidential funds. At panghuli, inabandona ni VP Sara Duterte ang kanyang tungkulin bilang halal na opisyal dahil binasta-basta niya ang otoridad at responsibilidad ng Kongreso na investigahan ang budget ng kanyang opisina. Sa mga sumunod na panahon, habang dinidinig ng Kamara ang budget ng OVP, mulat siyang umabsent sa budget hearings at umiwas sa pagsagot sa mga tanong na nagsisiyasat sa kung paano binastos ang milyon-milyong piso at anong magkano rin ang dapat ilaan sa mga susunod na taon given yung track record ng spending. Madam Chair, anong ehemplo at mensahe ba ang pinapakita nito sa kabataan? Ang pondo na dapat napupunta sa edukasyon, sa pagdevelop ng kabataan, ay nilustay ng dapat namumuno nito, hindi po katanggap-tanggap. Madam Chair, sinaan itong lahat sa reklamong nadalahad ng mga aligasyon of facts constitute betrayal of public trust. Ang complainants ay sumumpa din nakabase sa personal knowledge or authentic records ang mga nilalaman ng reklamo. Sufficient in form and substance, therefore, ang reklamo. Kaya wala pong rason kung bakit hindi dapat ito tumuloy-tuloy sa hearing proper. Higit pa sa mga technical na kahingian, matagal nang hinahanap ng taong bayan ang pananagutan ni VP Sara Duterte sa kanyang mga ginawa na nakadetalye sa reklamo sa mga reklamong nakahain laban sa kanya ngayon. Malinaw ang mga ang panawagan ng taong bayan. Ituloy ang proseso ng impeachment hanggang sa tuluyan siyang mapanagot. Kaya nung simula hanggang ngayon, hanggang dulo, this representation and the Filipino youth will be here, working, laying down the truth, and clamoring for justice, hanggang makamit natin ang pananagutan at justisyang deserve ng mamamayang Pilipino. Dito po nakataya ang kinabukasan namin. Papalagpasin ba ng kamarang ito ang mga malalim at maraming alegasyon ng korupsyon o magiging masusi sa pag-imbestiga at syempre ituloy-tuloy ito hanggang makamit yung tunay na pananagutan. Madam Chair, this impeachment has been long overdue. So allow me to reiterate, bilang mga mambabatas, hindi dapat tayo matakot na ungkatin ang katotohanan at panagutin ang mga nasa katungkulan. Ang hiling ng kinatawang ito, that the Filipino people who suffered from disasters and lacking basic social services because of misuse and abuse of public funds see their day in court. Let the Filipino people repose their trust in the public office that deserves it. and does not betray it. It is no surprise that the following call has saturated the streets nationwide in the past weeks. Marcos Duterte, walang pinag-iba, parehong kurakot, pahirap sa masa. And so we, the Filipino youth, echo the call of the people. Lahat ng kurakot dapat managot mula sa baba hanggang sa tuktok. Thank you, Madam Chair, for your indulgence. And I also wish to extend the same courtesy to also my fellow co-endorser, Representative Sara Elago. Thank you, Madam Chair.
Thank you, Honorable Con. Now we recognize the Honorable Sara Elago.
Maraming salamat, Madam Chair. At isang makabayan at palaban na pagbati sa lahat. Ang Gabriela Women's Party ay paninindigang iniendorso ang Castro et al. Verified Impeachment Complaint laban kay Vice President Sara Duterte. Ayon sa Verified Impeachment Complaint, batay sa betrayal of public trust at batay sa mga dokumento at testimonya sa mga pagdinig kung saan nalantad ang paggamit ng confidential intelligence funds, malinaw na ang Vice Presidente ay may buong otoridad, may buong kaalaman sa pagpapalabas, paggamit at pag-uulat ng mga pondong ito. At kung may otoridad, may kaakibat na ganap na pananagutan. Malinaw na batayan ng betrayal of public trust ang pang-aabuso sa diskresyon sa 612.5 million confidential funds mula December 22 hanggang third quarter na 2023. Sino makakalimot sa 125 million na confidential funds na ginasta lamang sa loob ng 11 araw? Ang paggamit ng confidential funds nakabatay sa pinakamataas na antas ng tiwala na ang opisyal, ang opisina na humahawak nito ay gagamitin lamang ang confidential intelligence funds para sa layunin na naglaanan at mahigpit susunod sa mga batas at mga patakaran. Ngunit winasak ang tiwalang ito. Nabigong magsubite ng kumpleto at maayos na liquidation reports sa COA at mas masahol, may mga huwad na accomplishment reports at gawa-gawa acknowledgement receipts. Ayon sa reklamo, sa ilalim ng kanyang utos, may mga tauhang nagpeke ng mga dokumentong isinumite mismo sa COA upang magmukhang may mga activities o pangyayari na ganap kahit pawala naman. Ang ganitong gawain ay hindi simpleng issue lamang sa paperwork, kundi pagsira sa integridad ng mga institusyon at pagnanakaw sa karapatan ng mamamayan na malaman ang katotohanan. Dagdag pa, ang sadyang pagtanggi na kilalanin ang oversight function ng Kongreso ay pagbaluktos sa mga sistema ng pagbabantay sa kapangyarihan. Ang tinatawag na pusit na taktika, pag-iwas o paglusot para lumabo ang usapan sa mga budget hearings at ang pagpupos na hindi dumalo ang buong OVP sa mga pagdinig ay pagyurak sa isang kapantay na sangay ng pamahalaan at pagtatangkang at pilit na umiwas sa pananagutan. Taong bayan ang biktima ng pagwawaldas at paglulustay ng pondo na kaugnay nito. Mga ordinaryong mamamayan na nagpapagod at makapagbayad ng patong-patong na bubis. Mga ordinaryong mamamayan na sa araw-araw ay umaasa na ang kanilang pinaghihirapan sa araw-araw ay makikita sa mga serbisyong abot kamay at may kalidad. Sa edukasyon, lusugan, sa pabahay, at marami pang ibang serbisyong panlipunan na lubos na kinakailangan ng taong bayan. Habang hirap na hirap ang ordinaryong kababaihan sa pagbabudget sa araw-araw, limpak-limpak na salapi pala ang winawaldas lamang ng ating mga pinakamatataas na opisyal. At habang daang-daang milyong piso ang mabilis na winawaldas para sa mga lihim na gastusin, nananatiling kulang na kulang ang mga silid-aralan, mababa ang sahod at suportang natatanggap ng mga guro at mag-aaral. Kaya naman, malinaw ang pattern ng pagkakanulo sa tiwala ng publiko, ang pag-abuso sa kapangyarihan, pamimeke ng mga record, at pagharang sa pananagutan. Kaya may inaming hinihikayat ang komite na ito at ang buong kapulungan, suportahan natin ang reklamo ito upang kairalin ang prinsipyong walang sinuman, gaano man kataas sa posisyon, ang makaiiwas sa pananagutan. Walang sinuman, gaano man kataas ang posisyon, ang higit sa batas at higit sa interes ng sambayang Pilipino. Maraming salamat.
Thank you, Honorable Elago. That completes the endorsers of the first impeachment complaint. I understand that I made mention about the sponsorship speech for the second impeachment complaint referred to as the et al. Impeachment complaint endorsed by Honorable Representative De Lima and Honorable Representative Percy Sendanya. Nevertheless, I wish to share to the committee that the chair is in receipt of the letter from our endorsed Congressman Sendanya and Congresswoman De Lima. I am likewise in receipt of letter from the complainants of the same impeachment complaint, the D et al. Impeachment complaint. And for this matter, we are directing the committee secretariat to kindly provide a copy of these two letters to the justice members. The letters apparently manifest the withdrawal of the endorsement of this impeachment complaint, that is for Congressman Sendanya and Congresswoman De Lima. They are manifesting as well their support to the third impeachment complaint, the one filed by Reverend Father Joel Sabalya et al. For the letter of the complainants of the second impeachment complaint, they are making the same manifestation of their intention to withdraw the impeachment complaint, as well as their intention to support the third impeachment complaint filed by the same Reverend Father Joel Sabalya. For this matter, I wish to request for confirmation of this letter, first from our endorsers. So the chair recognize the Honorable Sendanya first, and then the Honorable De Lima.
Yes, Madam Chair, we confirm that the letters that you are in receipt of came from our offices and that these were duly signed by the complainants from the second impeachment complaint. And in this light, Madam Chair, may I make a short manifestation?
You may continue, Honorable Sendanya.
Thank you very much, Madam Chair. Magandang umaga po sa ating mga kasama dito sa Committee of Justice at sa ating pong mga guests ngayong araw na ito, sa mga kababayan nating nag-aabang kasi 2 years in the making na ang pagpapanagot sa ating Vice Presidente. I wish to manifest that upon serious consultation with the petitioners of the second impeachment complaint, which I and Representative De Lima endorse, they intend to withdraw their case and instead throw their support behind the third impeachment complaint. Gumawa po sila ng formal na liham na nilagdaan ng lahat ng complainants, 17 in all, at ang ilan po ay kasama natin dito ngayon sa loob ng bulwagan at isinumite sa komite at gayon din sa Office of the Secretary General. Kasama ng mga complainants na iskondiinan na hindi ito pag-urong, kundi pagpapatuloy na kanilang sinimulan, kung matatandaan po ng ating mga kababayan, higit 1 taon na ang nakararaan. From the beginning, their intent in filing was clear. Build the strongest case that will hold Vice President Sara Duterte accountable for her acts of corruption and abuse of power. Their support for the third impeachment complaint well advances this goal and ensures that an airtight and strong case will be the product of the committee's deliberations. In essence, the second impeachment complaint is similar to the third, and thus, this committee will be spared from prolonging this process. Every minute and every hour we prolong this impeachment gives the Vice President another opportunity to look for loopholes to evade accountability again and again. Ngayong wala na ang second impeachment, sa katunayan, mas pinabilis nito ang proseso ng impeachment sa ating komite. Ngayon pa lang, may ibang kaalyado na ang Vice President na natutuwa at nagdidiwang dahil nag-withdraw ang second impeachment complaint, thinking this shows a weakening of the case against her. Pasensya na po kung babasagin ko ang inyong trip. Mas pinadadali nga po natin ang pag-i-impeach sa kanya. With one less complaint, we are now expediting Vice President Sara Duterte's long-delayed day of accountability. Madam Chair, dear colleagues, higit sa 1 taon na mula noong inendorso ko ang unang impeachment complaint noong December 2, 2024. Our complainants have patiently waited and have shown their unwavering commitment to the truth, justice, and accountability. Naghihintay sila ng matagal na sagutin ni VP Sara ang aligasyon laban sa kanya. And hopefully, their long wait will not be for naught. Tuloy ang laban, and as Deputy Minority Leader and ex-officio member of this committee, I fully trust that this committee will decide on the merits of this case. Nang sa wakas, ay mahatid na natin ito hanggang sa Senado. Thank you very much, Madam Chair.
Thank you, Honorable Sendanya. Now we will hear from the Honorable De Lima in line with the letter withdrawing the impeachment complaint.
Madam Chair, may I just make a...
May we hear first the endorser, Honorable Nasal. The Honorable De Lima is recognized.
Thank you, Madam Chair. Madam Chair, honorable colleagues, this representation likewise confirms the intention of the complainants in the D et al. Complaint, the first complaint, to withdraw their complaint. And that is manifested by the filing of both the letter seeking withdrawal and also the letter of the endorsers seeking likewise the withdrawal. Sa pagsampa ng reklamong impeachment noong February 2, malinaw ang pakay ni Kiko D et al. Mga kasama niya, D and mga kasama niya. Mapanagot sa mga akusasyon ng katiwalian at paglabag sa batas ng pangalawang Pilipino. Grupo rin nila ang naghain ng isa sa 3 impeachment complaints. In fact, sila po yung una noong 1 taon, kung saan ako ay tumayo pang tagapagsalita nito. Gaya ng marami, natuwa sila na naihain ng Kongreso, ng House, ang articles of impeachment sa Senado. Tulad din ng marami, nabahala sila sa pagkabalahaw o pagka-stop ng kaso sa Senado bilang impeachment court. Gaya ng marami, nanlumos sila sa naging desisyon ng Korte Suprema na iantabi on technicality yung articles of impeachment in transmit ng Kamara. Alam po nila ang proseso ng impeachment. Alam nila na kailangan makakuha ng sapat na bilang sa sapat na panahon upang maitawid ang reklamo mula sa komite papuntang plenaryo at mula plenaryo ay madala ang articles of impeachment sa Senado sa lalong madaling panahon. Siyempre po, sila ay umaasa na may kasabay na panalangin na sometime this year, this Congress, litigating na forthwith sa impeachment court ang pangalawang Pangulo. Conscious sa tumatakbo at sa kinakailangan bilang sa komite, plenaryo sa Senado, pinag-isipang maigi ng mga complainants kung ano ang mabisang estratehiya at mainam na mga taktika upang umusad ng mabilis at mas epektibo ang reklamong impeachment. In the statement that they released yesterday, the complainants D et al. Informed the public that they have decided to withdraw the case while committing to lend their full support behind the third complaint containing the same grave allegations and substantial evidence as theirs. Incidentally, the third complaint was likewise endorsed by this representative. According to the complainants, quote, consolidating our support behind the third complaint will strengthen our position and help move the case forward to the Senate impeachment court. We believe that the impeachment process must proceed at the earliest possible time, free from procedural limbo and unnecessary legal delays that would otherwise obstruct the process. End of quote. Sang-ayon po tayo rito. Sang-ayon po kami ni Representative Sendanya as endorsers. Sa katunayan, humahanga po tayo sa naging pasya nila na iurong na lang ang kanilang reklamo para bigyang daan at masuportahan ang kaparehong kaso na isinampa ng third set of complainants para ma-consolidate ang efforts, mapibilis ang usad ng impeachment. In short, the complainants in the second complaint, D et al. Complaint, are withdrawing the complaint in order to secure more significant and strategic gains down the line, which includes the streamlining of the proceedings and cutting down of some precious time that could have been consumed by needless consideration, needless debate, as well as procedural delays and detours that this Congress and the people could no longer afford. In the final analysis, it does not matter much to the complainants, whose name will be in the end credits, so to speak, because they are still interested parties. Their sights have always been set on a fixed goal: impeach the vice president and hold her accountable for the grave offenses she committed against the Filipino people. Here, now, to paraphrase the lyrics of a song, I don't care how we'll get there, just get there while we can. And so, I make a record and manifest the D et al. Are withdrawing their impeachment complaint. This confirms the letter that they have filed earlier with this committee, as reiterated and supported by this representation and Representative Persis and Dania in a separate letter that we have also filed with this committee. I so respectfully manifest, Madam Chair, maraming salamat po.
Thank you, Honorable De Lima. Just to record, the chair is in possession of this letter dated March 2, 2026, signed by the Honorable Congressman Sendanya and the Honorable Congresswoman De Lima. May I request the Secretariat to please bring this to the endorsers, just to confirm for the record that this is the letter of the withdrawal of their endorsement of the second impeachment complaint.
Madam Chair. May I just
Honorable
make a
Gasal,
point of
may we
clarification?
finish first the presentation of the withdrawal of the impeachment complaint, so as not to the presentation of their intentions.
Thank you,
Thank you.
Madam
I
Chair.
will call you after the complainants.
Okay, thank you, ma'am.
While we are waiting for the confirmation, we would like to acknowledge the presence of the Honorable Deputy Speaker Janet J. Garin, the Honorable Congressman Z. Alonto Adjong from the 1st District of Lanao del Sur, and the Honorable Congresswoman Maria Rene Ann Lourdes Matibag from the 1st District of Laguna. May we hear the confirmation of the Honorable Sendanya?
We confirm, Madam Chair.
Thank you. The Honorable De Lima?
This representation likewise confirmed, Madam
We
Chair.
place on the record that the endorsers confirm that the letters within the endorsement are the same letters that they sent to the Justice Committee. Of course, we understand that this is a formal proceedings. The complaint is likewise under oath, so we want to do it in the proper way as well. There is a letter withdrawing the complaint signed by the complainants, but we would like them to formally confirm this letter the same way that the endorser confirmed the withdrawal of the endorsement of the second impeachment complaint. So for this matter, we would like to recognize the complainants, signatories of this withdrawal impeachment complaint contained in the letter dated March 2, 2026, to confirm the withdrawal of the second impeachment complaint. Perhaps with the indulgence of the members, we are calling Francisco Joseph Aquino D, Sylvia Estrada, Claudio Tercita Quintos Deles, Eugene Louis Gonzalez, Maria Yvonne, Kristina Jereza, Father Flavio Villanueva, Father Robert Paguirre, Father Sister Susan Santos Esmile, Carl Patrick Sukat, Leia Lopez Navarro, Matthew Christian Silverio, Teodoro B. Bagilat, Ezekiel Ben Rivera, Ana Kubakob, Alicia Murphy, and Rowena Amon, and Joshua Fred Tolentino Mata. Kindly approach complainants, please. Perhaps Mr. Francisco Joseph Aquino can speak for the complainants, but kindly approach our conference table. I am requesting the COMSEC to administer the oath to our complainants. This is a very significant intervening event that the complainants are withdrawing the impeachment complaint, and the endorsers are likewise withdrawing their endorsement of the same impeachment complaint. That's why we want to do it formally, the same way that they filed this impeachment complaint. COMSEC, kindly administer the oath. Please
Madam
raise
Chair,
your right
Madam-
records of our committee meeting today.
So we don't need to ask them questions, Madam Chair.
No, just a confirmation of the withdrawal that they're doing right now. A confirmation of the withdrawal that they are doing right now through this letter.
Okay, thank you very much, Madam Chair.
Thank you, Honorable Adjong. The COMSEC is directed to administer the oath.
Please raise your right hand. Do you swear to tell the whole truth and nothing but the truth before this committee? Please answer. Thank you.
Thank you, COMSEC. Now the chair is in possession of the letter signed by the complainants. I already mentioned your names. This is dated March 2, 2026. May we hear for the record that you are confirming the withdrawal of this impeachment complaint? I hope this is a very significant intervening event because this is an impeachment complaint that even before it is heard, you wish to withdraw already. So may we recognize that Mr. Francisco Joseph D. I'm sorry.
Madam Chair, on behalf of the 17 complainants of the second complaint, with me are myself and 7 other complainants now. I am confirming our intention to withdraw our impeachment complaint.
Thank you for the record as well. We are directing the committee secretariat to kindly hand this letter to Mr. D to confirm that this is the same letter withdrawing their impeachment complaint.
Madam Chair, we confirm that this is a letter that we submitted this morning.
Thank you, Mr. D. In the presence of the justice members and all the Filipino people who are watching right now, Mr. D, in behalf of all the complainants, is confirming the withdrawal of their impeachment complaint.
Madam Chair.
Thank you, complainants. You may
Madam
take your
Chair.
seat. The Honorable Flores is recognized.
Madam Chair, in view of the withdrawal and the confirmation by the complainant D et al. That they are withdrawing the impeachment complaint, as well as the withdrawal of the endorsement by Representative Percival Sendanya and that of Representative Leila de Lima, I move that the committee accept and approve the withdrawal of the said complaint, Madam Chair.
There is a motion to accept and approve the withdrawal of the impeachment complaint. Do I hear a second? Then there is there any objection? Hearing none, the motion to approve, to accept and approve the withdrawal of the second impeachment complaint referred to as D et al. Is hereby approved.
Madam Chair.
Before I call you Honorable Dumogan, I will call first the Honorable Nasal. The Honorable Nasal is recognized.
Kaya I just wanted to raise a point of clarification. With due respect to our colleagues, may we seek clarification lang po on the propriety of the proceeding with sponsorship speeches by the representatives who filed the impeachment complaints in light of the Supreme Court's final and executory ruling declaring the Feb 5, 2025 articles of impeachment unconstitutional for violating the one-year bar under Article 11, Section 3, Paragraph 5 of the Constitution. Given that the Supreme Court has already affirmed with finality that no new impeachment can be commenced earlier than Feb 6, 2026, reckoning from Feb 5, 2025 as the operative date, and considering that there are claims, one na lang, were filed on Feb 2, 2026, it would appear that the constitutional one-year prohibition may still be subsisting. So in this regard, Madam Chair, may this committee first determine whether the complaints presently under consideration were filed in accordance with the Constitution timeline as affirmed by the Supreme Court. Thank you, Madam Chair.
Honorable Nasal, the committee notes your manifestation, but it is believed that the discussion as to whether or not it was filed within 1 year, beyond the 1-year prohibition period, should be part of our determination of sufficiency in form, because that constitutes the timeliness of filing the impeachment complaint. Nonetheless, your manifestation is duly noted. We will come to that, Honorable Nasal.
Madam Chair.
Thank you. The Honorable Vice Chair Dumogan is also raising his hand.
Thank you, Madam Chair.
Please be guided that we are still on the sponsorship speeches.
Yes, Your
We just heard the endorsers and the complainants on the withdrawal of the second impeachment complaint. We haven't reached yet the determination of sufficiency in form. We're still hearing the sponsorship speeches.
That's correct. But before I will go to that, I like to take advantage of the presence of the complainants who had just withdrawn. Just to me, it's very important to affirm their allegations.
You would like to make a manifestation of their
Yes.
withdrawal because the withdrawal has been accepted and approved.
Yes, Your Honor. But it has nothing to do with the withdrawal. They will withdraw just the same. But just like them to affirm the second paragraph of their statement, their withdrawal, that they are withdrawing the complaint because the third complaint.
Yes, the same has been confirmed earlier,
Okay.
Honorable Vice Chair Dumogan.
Yeah. Second, Madam Chair, we are at the stage of determining sufficiency in
Not
form.
yet, Honorable Dumogan. We're still hearing the sponsorship speeches of the endorsers.
Yes,
We will come to that in a while.
that's why if we go to the determination of sufficiency in form, and we have this, the sponsorship are somewhat geared already in the determination of the sufficiency in substance. Why can we not limit whether or not it is sufficient in form so that later on we can now proceed with the determination of sufficiency in substance? Otherwise, we are prolonging the proceedings. They can expound when we will go to the issue of sufficiency in substance. At this point in time, whether the complaints has allegations which can be considered as impeachable offense without going to the merits, it can be verified in the verification just based on personal knowledge or authentic documents. That's all that we are going to determine, and including possibly the 1-year bar rule. Those are the only thing to me to determine, so that when we will go to the sufficiency of substance, that will be the time we will take the allegation.
Honorable Vice Chair Dumogan, I understand that you are very much eager to reach the discussion of the sufficiency in form. Nevertheless, please understand that they are the endorsers of the impeachment complaint, and of course, we understand that the sponsorship speech is to support the entire impeachment complaint, not necessarily the form and the substance alone. Nonetheless, your manifestation, Vice Chair Dumogan, is very much by the committee. So, with indulgence of all the members, the Honorable Kong Joboy Aquino.
Thank you, Madam Chair. Just like manifestation, Madam Chair. I commend the Honorable Congresswoman and Akbayan Party List for its courage and sound judgment in withdrawing the complaint in deference to prevailing legal considerations and in giving way the other impeachment complaints to proceed with the committee's determination as to sufficiency and both form and substance. Thank you, Madam Chair.
Thank you. Are there any other justice members who wish to manifest? The Honorable Erice is recognized.
This is somehow a parliamentary inquiry. Since we approved the withdrawal and their support for the third impeachment, will they be the part of the complainants in the third impeachment complaints? Thank you.
It is believed, Honorable Erice, that the letter manifests only their support to the third impeachment complaint, but it does not necessarily make the complainants party to the third impeachment complaint.
Thank you, Madam Chair.
Thank you.
Madam Chair, further,
The Honorable Rodriguez.
thank you. Further in answer to that, it is now time barred because the filing has already been done.
Correct.
So there can be no additional. It will be already a deviation of what we have in the committee now if we allow those who have withdrawn to become complainants or the endorsers to be included as endorsers. It is now time barred. Thank you, Madam Chair.
Thank you, Honorable Rodriguez.
Madam Chair,
The Honorable Cheljo.
thank you, Madam Chair. Just a brief manifestation. First, a commendation to the complainants led by Sir Francis Kikodi from the complaint. The Committee on Justice can now focus on doing its job instead of wasting time arguing over technicalities. I also commend the complainants for their vigorous and relentless pursuit of accountability. They have demonstrated a deep concern for public responsibility. And therefore, Madam Chair, I move that the committee recognize them merely as interested parties, as they have shown that interest over the last 7 years, and also allow to observe our proceedings, not just today, but the future. So move, Madam Chair.
Honorable Rodriguez, would you like to comment to the motion of the Honorable Jokno? He's moving to consider the complainants as interested party in our current impeachment proceedings.
No need to consider them as interested parties. They can come here. Of course, they're interested and we're open. This is always public proceedings. And so we don't need to officially make them participants in this because they are not official participants because only the endorsers and the complainants are official participants and the committee members. Certainly, we welcome those who have withdrawn from the second complaint to be present all the time as this is a public proceedings. Thank you, Madam Chair.
In addition to the earlier manifestation of the Honorable Rodriguez, it is understood that the initiation process has been completed already. Thus, it triggers the running of the one-year prohibition period, which likewise means that we cannot change as to the parties' impeachment complaint, no? Nevertheless, they are very much welcome, as stated already by the Honorable Rodriguez, to participate in any, to witness the proceeding at any stage of the same, no? They can come and witness our entire impeachment proceeding. Honorable Jokno, would you still like to push your motion?
I will respectfully withdraw the motion.
Thank you, Honorable Jokno. Thank you. If there are no other manifestations, I would like to acknowledge first the Honorable Congressman Stephen James Tan from the 1st District of Samar. Thank you for coming. And the Honorable Congressman Paulo Henry M. Marcoleta from Saguit Party List. We will acknowledge as well the presence of Deputy Speaker Bambi Imano. Thank you for coming, sir. We would like to proceed to hear the sponsorship speeches. We are now the third impeachment complaint, and we recognize the Honorable Laila de Lima to her sponsorship speech of the third impeachment complaint referred to as Sabala et al. Impeachment complaint. You may proceed, Congresswoman.
Thank you, Madam Chair. Madam Chair, honorable members of this committee. I am honored to be the endorser of the verified impeachment complaint filed by Reverend Father Joel Sabal against Vice President Sara Duterte. Let me be clear at the outset. This endorsement is not a declaration of guilt. It is not a politically motivated gesture. It is not a personal act. It is a constitutional duty. The Constitution entrusted this House with this responsibility precisely for moments like this, when serious, detailed, and grave allegations are placed before us. Katulad na lamang ng verified complaint na ito ngayon. Ito ay tahasang nagsasaad ng mga sumusunod na mabibigat na sakdal. Una, the Vice President committed culpable violation of the Constitution and betrayed the public trust by committing plunder and or malversation, graft and corruption, and other high crimes sa umano'y pag-amas at pag-convert ng hindi bababa sa 500 million pesos mula sa confidential funds ng Office of the Vice President para sa 2022 at 2023. Hindi maliit na halaga ang kalahating bilyong piso. Hindi ito simpleng administrative lapse. Ito ay pondo taong bayan. Ikalawa, that she committed culpable violation of the Constitution and betrayed the public trust sa umano'y pagkamkam at pag-convert ng hindi bababa sa 112,500,000 mula sa confidential funds ng Department of Education noong 2023 in her concurrent capacity as DepEd Secretary. Ang pondo para sa edukasyon, para sa mga bata, para sa kinabukasan, ay hindi maaaring mabalot ng pagdududa at kakulangan at mga questionableng dokumentasyon. Ikatlo, that she committed culpable violation of the Constitution and betrayed the public trust by corrupting and bribing officials of the Department of Education. If envelopes containing cash were indeed distributed to influence official actions, that is not merely an ethical act, it is a direct assault on public trust. Ika-apat, the committed culpable violation of the Constitution, betrayed the public trust, and committed high crimes in contracting to murder or assassinate the President, the Free, and the former Speaker of the House. Kung ang isang halal na pinuno ay hayagang nagsabing siya ay nakipag-usap sa isang assassin para patayin mismong Pangulo ng Republika, hindi ito retorika lamang. Masagwa pa rito. Hindi lamang ang nagplano ng pagpatay ay ordinaryong kawani ng gobyerno, ordinaryong Pilipino, kundi ang pangalawang Pangulo, ang constitutional successor ng mismong pinapapatay niya. Saan panig ng mundo o ibang mga bansa nakakita na merong napakataas na opisyal, yung pangalawang Pangulo, na lantarang nagbanta sa buhay ng pinakamataas na opisyal. Ito ay malinaw na usapin ng pambansang seguridad. Ito ay usapin ng katatagan ng ating pamahalaan. Ito ay usapin ng paggalang sa mismong konstitusyong kanyang sinumpaan. Ikalima, that she committed culpable violation of the Constitution and betrayed the public trust in amassing unexplained wealth and failing to disclose all her properties and interests in her SAL-Ns, alinsunod sa Section 17, Article 11 of the 1987 Constitution. Ang SAL-N ay hindi dekorasyon. Ito ay mekanismo ng transparency. Kapag may malaking pagtaas ng yaman na hindi maipaliwanag ng sapat, at kapag may mga nakatagong yaman, tukuling ng institusyon na siyasatin ito. Ika-anim, that she by herself and or in concert with others committed culpable violation of the Constitution and betrayed the public trust in committing acts of political destabilization and the high crimes of sedition and insurrection. Ang panunumpa sa konstitusyon ay hindi simboliko. Ito ay panata ng katapatan sa Republika. Kung may mga kilos o pahayag na nag-uudyot ng paghihimasok o paghihimagsik o destabilization laban sa halal na pamahalaan, hindi maaaring ipagwalang bahala yon. To support those grounds, total six specific grounds, complainant Sabali et al. Made a detailed recital of facts, which were mainly matters of public record and knowledge that were clearly constitutive of the enumerated offenses. Considerably, most of the factual allegations and the access in the Sabali et al. Complaint were the same as those contained in the articles of impeachment that were sent to the Senate in February 2025. Those articles were endorsed by more than one-third of the membership of the 19 Congress, numbering 250 representatives at that time. Fortunately, many of those endorsers are still members of the current Congress. Therefore, I have to say, it is absurd plain now the pieces of evidence contained in Sabali et al. And the other impeachment complaints, precisely because these are exactly the same accusations and evidence that caused the impeachment last year. Nothing changed. The grounds, the facts, and the evidence remained valid. This should still be enough to impeach her in this time. In fact, in the case of Duterte versus House of Representatives, GR number 278353, both in the Supreme Court's original decision of July 25, 2025, and the January 28, 2026 resolution on the motion for reconsideration, it was underscored, as sabi na rin po ito ng ating Madam, that the Vice President was not absolved. In the High Tribunal's own words, quote, at the House's discretion, the grounds raised in the articles of impeachment may again be raised based on any evidence that may have been discovered, if any. End of quote. As to the opinion of some people that there are no smoking guns in this and other complaints, I beg to disagree, Madam Chair. The video containing the Vice President's threat to kill the President, the First Lady, and then House Speaker, as well as the media interview where she affirmed it, is a smoking gun. The news documents evidencing payments or the debts with fictitious names are smoking guns. Sabalia et al.'s complaint is replete with many other documentary evidence which are also smoking guns. And even assuming, without conceding, that the evidence in the articles are not or no longer smoking guns, we have them this time. We will produce them in the form of compelling testimonies and newly discovered material evidence. One more time with things, as the lyrics of a song go. I reiterate, this House has impeached Vice President Sara Duterte before. The records are clear. This House already determined at least once that the allegations against her were serious enough to trigger the constitutional process. So I ask, respectfully, but directly, what has changed? Have the allegations disappeared? Have the official reports and audit findings been withdrawn? Have the sworn testimonies before the previous House hearings been recanted? Or is the only material development the public declaration that the Vice President may seek the presidency? Maihalin ba ito sa isang supervening event sa law on obligations and contracts? Yung madalas ding tawagin sa batas na fortuitous event na pangyayaring hindi inasahan o kung inasahan man ay hindi naiwasan, already rendered the performance of an obligation impossible or extremely difficult. Pero sandali lang po. Hindi ordinaryong obligasyon at ang sariling interes ang nakataya rito sa impeachment process. Alay rito ang tinumpaang tungkulin natin sa ating bayan at sa ating saligang batas. Kaya kung wala namang nagbago sa mga facts at sa batas, anong dahilan para magbago ang paninindigan? O mas malala pa, anong rason para tuluyang mawala paninindigan? If we found the allegations sufficient before, by transmitting the articles of impeachment to the Senate, then consistency and principled conviction demand that we uphold what this House had firmly decided on before. Hindi maaaring mag-iba ang ating pasya kung hindi naman nagbago ang ebidensya. Oath is to the Constitution, not to political convenience. Our loyalty should be to the Filipino people, not to partisan interests. Public office is a public trust. That principle applies to every public officer, without exception, without fear, without favor. For reasons grounded in constitutional fidelity and institutional responsibility, I urge this committee to allow the constitutional process to move forward. Let the evidence be tested. Let accountability be pursued. Let the Constitution prevail. And finally, so we pray that the lane we're treading here be paved with the same moral lines of truth and accountability that our people drew at EDSA 40 years ago. We pray that as we traverse this path now, as representatives of the people, we be mindful of those constitutional boundaries, those limits of integrity, honesty, and decency that the Filipinos have set against war and privilege. For crossing those moral lines, for desecrating those constitutional boundaries, let us impeach President Sara Zimmerman Duterte. Maraming salamat po.
Thank you, Honorable De Lima. Now we shall hear the sponsorship speech. Honorable Dania, would you like to make a sponsorship speech as well? No. This is only Congresswoman De Lima. All right. Now we proceed to the fourth impeachment. This is the Cabrera impeachment complaint. Our endorsers are the Honorable Deputy Speaker Paulo Ortega and Congressman Benny Abante. DS Paulo Ortega is recognized to deliver his sponsorship speech. Maybe you can use Kong Shell's microphone first. Paige, kindly address the microphone.
Thank you, Madam Chair. The Honorable Abante has agreed to let me experience Citizen Lane, a courtesy lane for today's endorsement statement. Honorable Chairperson Jervil Louise, honorable members of the Committee on Justice, our esteemed guests, public whom we serve, na imbaga bigayo amin na po. Tayo ay naging isang bansang labis ang pagkahati-hati hanggang sa makalimutan na natin ang pagdating sa paglilingkod sa bayan. Dapat managot ang sino man o anumang kulay na kanyang kinakabilangan. Ang pananagutan ay nangangahulugang paglalantad sa mali at paglalabag sa matagal nang umiiral at patuloy na sumisira sa ating mga institusyon. Now is the moment right for remembrance that it was nearly 4 years ago that the Vice President stood before us, raised her hand, and pledged faithfully and conscientiously to fulfill her duties as the Vice President of our country, preserve and demand our Constitution, execute our laws, do justice for every man, and consecrate herself to the service of the nation. Nakakalungkot po na isipin na nakalipas na po ang halos 4 na taon mula nung ipahayag. Ang mga pangakong iyon ay mukhang hindi naman natutupad. Sa kasalukuyan, ang Vice Presidente ay naharap sa mga aligasyon at paratang ng pagtataksil sa tiwalang ipinagkaloob sa kanya ng taong bayan. Mga aligasyon na hinggil sa umiiral na kultura at panunuhol at ibang katiwalaang matagal nang sumisira sa integridad ng ating institusyon. Culpable violation of the Constitution, betrayal of public trust, graft and corruption, at iba pang mabibigat na krimen. Under letter A, sufficiency in form, Honorable Chairperson Louise and the Honorable members of the Justice Committee, batay sa ating procedure in impeachment proceedings, upon due referral, this committee shall determine whether the impeachment complaint is sufficient in form. Kaugnay nito, ang isang impeachment complaint ay kinakailangan na may kalakip na verification that the complainant has read the complaint and that the allegations are true and correct for his personal knowledge or based on authentic records. To this end, I invite the attention of the Honorable Committee to pages 71 and 72 of the verification page that the 4th impeachment complaint or the Cabrera complaint pursual of the pages show that this complaint has been duly verified by the complainant himself, Attorney Nathaniel G. Cabrera, on the 18th of February 2026, under oath that the complainant deposed that he read and understood the contents of the complaint and that the allegations of the complaint are true and correct based upon personal knowledge and based upon authentic documents of the same date, and the verification is also duly notarized. Page 70 of the 4th complaint shows that it was signed by Attorney Nathaniel Cabrera. Higit pa rito, bilang bahagi ng formal na proseso, ako at si Representative Bienvenido M. Abante Jr. ay pumasa ng isang resolution of endorsement dated February 18, 2026, duly subscribed and sworn before the Honorable Secretary General Attorney Cheloy E. Villacaria Garafil. Madam Chair, it is respectfully submitted that the 4th impeachment complaint of the Cabrera complaint is sufficient in form and that it be allowed to proceed to the next stage of things. Maraming salamat po, Madam Chair.
Thank you, Honorable Deputy Speaker Paulo Ortega. Our parliamentary status, we have concluded on the sponsorship speeches. The remaining impeachment complaints. Those include the first impeachment complaint, referred to as Castro et al. Impeachment complaint. The third impeachment complaint, referred to as Father Sabal et al. Impeachment complaint. And the fourth impeachment complaint, referred to as Cabrera impeachment complaint. I wish to state for the record and for the guidance of all the justice members who just came, the second impeachment complaint has been withdrawn already by the complainants. Now we shall proceed to determine the sufficiency in substance. For the guidance of all the members, form. I'm just testing if you are all listening. Of all the members, I wish to summarize the process that will happen in the Justice Committee into 5. The first step is the determination of sufficiency in form. The second step is the determination of the sufficiency in substance. The third step, which is subject to the condition that the impeachment complaints are declared sufficient both in form and in substance, we shall issue the notice to the respondent for her to file an answer within the period of 10 calendar days, in which case the complainant is given as well a period of 3 days to file their reply, and from the date of reply, receipt of reply, the respondent is likewise given a period of 3 calendar days to file their rejoinder. On this step 3, determine if there is sufficient basis that supports the impeachment complaint. If in the affirmative, we shall proceed to step 4, and that is the hearing, where we would be inviting the complainants, the witnesses, and even the respondents. After the hearing proper, we will decide on step 5. That is the determination of probable cause, distance of probable cause, which shall be determined by the majority vote of all the members of the Justice Committee. That includes the ex officio members. The Honorable Labante. May we know the pleasure of the Honorable Abante? Would you like to make your endorsement also, sponsorship speech? I thought you gave that opportunity to D.S. Paulo Ortega. That's why I did not recognize you anymore. Nonetheless, let us hear the sponsorship speech of the Honorable Bishop Abante for the fourth impeachment complaint, that is Cabrera impeachment complaint. You may proceed.
Ay, iba. Oo.
Sound check.
Ay, ayan.
Ayan. Alright. Magandang umaga po. Madam Chair, distinguished colleagues, mga kababayan, mga kapwa ko endorsers, magandang umaga sa inyo lahat. Alam nyo, ako po'y mahilig maglagay ng titulo sa aking mga speeches. At ang title po ng aking speech today is Duty, Honor, Principle. Tatlo po yun. Martin Luther King Jr. said, and I quote, "The ultimate tragedy is not the oppression and cruelty by the bad people, but the silence over that by the good people." End of quote. Madam Chair, there are moments in public life when silence is convenient, when silence is strategic, when silence is safer. But there are also moments when silence becomes complicity, when to look away is to participate, when to remain quiet is to permit the erosion of the very Constitution we swore to defend. I endorse this fourth impeachment complaint with Congressman Paulo Ortega, not out of anger, not out of citizenship, not out of personal animus. I endorse the fourth impeachment complaint because the allegations before us are grave and quite serious, because they strike at the heart of
constitutional order because they involve the alleged misuse of hundreds of millions in confidential funds, because they involve sworn affidavits, COA findings, documentary irregularities, and most chilling of all, public admissions that, if true, undermine the sanctity of lawful succession and the stability of government. We are not here to convict. We are not here to persecute. We are not even here to prejudge. We are here to determine sufficiency in form and sufficiency in substance. But allow me to stress that sufficiency is not a trivial threshold. It is a constitutional gate. And when credible, detailed, documented allegations are placed before us, allegations of betrayal of public trust, culpable violation of the Constitution, and corruption, and other high crimes, this committee does not have the luxury of indifference, because public office is a public trust. These words are not ornamental, Madam Chair. They are not decorative language placed in our Constitution for ceremonial speeches. They are a command, a standard, a warning. When confidential funds are alleged to have been encashed in vast sums and liquidated in implausible time frames, when audit findings raise red flags, sworn testimony describes physical transfers of cash outside normal channels, when public statements threaten the very officer's name in our Constitution, we cannot say this is we cannot say this is politically difficult. We cannot say let someone else handle it. Why? Because this is our constitutional duty. If the complaint is defective in form, we will say so. If it lacks ultimate facts, we will say so. If it is the standard required by the Constitution, we will say so. But if it meets the threshold, if it alleges ultimate facts supported by sworn statements and documentary annexes sufficient to warrant investigation, then we must allow the process to proceed. For the power of impeachment, Madam Chair, my dear colleagues, is not a weapon. It is a safeguard. It is not vengeance. It is accountability. It is not politics. It is constitutional order at work. History will not ask whether this was politically comfortable. History will ask whether we were faithful to our oath. We swore to preserve and defend the Constitution, not selectively, Madam Chair, not conditionally, not when it is convenient. If we remain silent in the face of serious allegations against one of the highest officials of the land, then we are not neutral. We are negligent. This hearing is not about personalities. It is about principle. It is not about ambition. It is about accountability. It is not about 2028. It is about 1987, the Constitution that binds us all. Let us therefore proceed with sobriety, as I beg this committee right now, Madam Chair. Let us proceed with fairness. Let us proceed without fear, because in the end, we answer not only to our colleagues, not only to our constituents, but to history and to God. As scripture reminds us in Micah 6:8, and I quote, He hath showed thee, O man, what is good, and what doth the Lord require of thee, but to do justly, and to love mercy, and to walk humbly with thy God. End of quote. Madam Chair, my dear colleagues, may we do justly, may we love mercy, and may we walk humbly as we discharge this solemn constitutional duty. Maraming salamat po, Madam Chair. Thank you.
Madam Chair.
Thank you, Honorable Abante. That finally concludes our sponsorship speeches. Honorable Suntay, if this concerns the sponsorship speech, because soon we will be proceeding to hear on the sufficiency in form, if that concerns form. Kindly use the microphone of the Honorable Padiernos. That's only the microphone. Page, kindly fix the microphone near to Honorable Suntay.
Hello po. Ayan.
Check this.
Thank you very much, Madam Chair. Well, Madam Chair, after hearing all the endorsers of the impeachment complaint, sangayon naman ako sa kanila dahil ang mga sinabi nga natin mga endorsers, there's been allegations now of misuse of hundreds of millions of public funds. Merong mga sworn affidavits, merong mga allegations na binitawan, merong usapin regarding betrayal of public trust, graft and corrupt. Kagaya nga ng sinabi ni Congresswoman Ranny ko, hindi dapat tayo matakot kung katinang katotohanan. Kagaya ng sinabi ng aking kaibigan, si Pastor Benny Bante, public office is a public trust. We should proceed with fairness and without fear. Bottom line, we have to be impartial. That's why I would like to raise this. In the light of serious allegations contained in a joint affidavit issued last February 23, that has been reportedly transmitted to the Ombudsman. There have been allegations that some members of Congress nakatanggap ng envelope, nakatanggap ng maleta. Ito'y naibigay, kung hindi sa opisina, sa townhouse. No, let me read this.
There's
You
a
will
point
be
of order,
because that's bearing. This is not an allusion
Order.
to prejudge the veracity of the allegation.
Honorable Suntay, there is a point of order.
This is also a point of
That is
order.
the hierarchy among all the motions.
Of this speech.
No, Madam Chair, this is very relevant because we are.
Please, Honorable Suntay, please wait until he finishes with his point of order. The Honorable recognized. Kindly use a microphone which is okay.
Madam Chair, the
speech of our distinguished colleague is absolutely relevant to the question of sufficiency of form and substance in the matter, and more importantly, my understanding of what he's stating today is that he's probably accusing members of Congress, members of justice, as receiving payments for the implementation of our mandate in the impeachment proceedings. So, which is which, Madam Chair? So I think his speech is out of order and should be decided promptly by the committee.
Okay, we heard the basis of the point of order of the Honorable Terry Ridon. Now we shall hear the answer of the Honorable Suntay.
Yes, Madam Chair. Ang problema sa
Kindly
kaibigan ko,
justify the relevance of your
He is
statement to the
something
current
done.
impeachment proceedings.
This is something na done. This is actually relevant not only in the determination of form and substance. This is relevant in the determining the impartiality of this hearing, which is very important. Madam Chair, this is not an accusation. Kaya nga, kung hinintay lang ako patapos, ewan ko bakit naman yung aking kaibigan, nagnagaliti ka agad at concern, you know, if we have nothing to fear, then we just listen. If we are not being alluded, why are we so guilty? So let me finish. The issue here is not to prejudge the veracity of the allegation. However, given the gravity of the claims and the potential impact on the credibility of the committee's proceeding, ang gusto ko maging malinaw lang po, hindi ko hinuhusgahan yung aking mga kasamahan o ipagpalatotoo ang mga aligasyon. Hindi rin po ito personal na laban sa sino man sa inyo. Sa katunayan, ang layunin ko ay kabaligtaran upang protektahan ang bawat isa sa inyo. Magbigyan kasi may listahan na nilabas eh. Ang gusto ko po sa ganitong pagkakataon, Madam Chair, naniniwala ako na mas mabuti na tayo mismo ang magharap at maglinaw ng issue. Kaya maging bulok kaysa maging bulong-bulungan pa ito. Tignan natin ang pagkakataon bawat membro ng committee. Pagkakataon mismo na mag-assess ng kanilang sitwasyon or if they can impartial member of this committee. Yun lang. Kung sa tingin nila they can be an impartial, then let's proceed. However, if they think that baka pagdudahan sila at pagdudahan yung lalabas dito na resulta, then let's allow them if they want to recuse.
Honorable Suntay, with all due respect, unless all your manifestations have complete relevance to the current impeachment proceedings, you are enjoined by the chair to proceeding to your manifestation.
That's why, Madam Chair.
Ordered.
Madam Chair, my point is just to...
Honorable Suntay, you are enjoined already by the chair to cease from manifesting, from making manifestations which are totally irrelevant to our current.
Thank you, Madam Chair. As I
Thank
mentioned,
you.
this goes to the impartiality of the committee.
You are
Thank you
assured
very
of the impartiality of the Justice Committee. Now we shall proceed to the determination of sufficiency in form. Thank you, Honorable Suntay. We will be suspending for 2 minutes to fix all the microphones. The meeting is resumed. We will now proceed to the determination of sufficiency in form. We have the other members.
Madam
The Honorable D.S. Guerin.
Madam Chair, prior to dealing with the indulgence of the members of this committee, since the allegations were baseless and not contained in an affidavit, and this is the subject of an impeachment complaint totally unrelated to what was mentioned, may I move that the words of the allegations as contained for congressmen getting money in the office and being delivered in the townhouses be stricken off the records. So move, Madam Chair.
There is a motion to strike off from the record the manifestation of the Honorable Sutay with respect to the money taken or received in relation to the...
Basically, Madam Chair, the statements, the allegation mentioned by Congressman, or my good friend, my very good friend, Congressman Suntay.
You are good friends to each other.
Very, Madam Chair. Very much, Madam Chair. So,
There is a motion to strike off from the record the manifestation of the Honorable Suntay about the money taken or received by allegedly by the members of the House. Is there a second? The same has been seconded. Is there any objection?
Madam Chair.
Madam Chair, I have no objection, considering it has been published.
The Honorable Marcoleta, are you objecting?
No, ma'am. In fact, I'm appealing to
Let us resolve first the motion.
reinstate the.
So you're objecting.
No, I'm appealing to reinstate the remarks earlier made by.
The motion is still pending. It's not yet resolved. If there are no objection, then the chair approves the motions to strike off from the record the manifestation of the money allegedly received by the House members from the manifestation of the Honorable Sui. So ruled. Honorable Marcoleta.
Madam Chair, I'd like to appeal. I think the remarks earlier made by
Is
Honorable.
that a motion for reconsideration?
It's more of a manifestation.
Okay, please manifest.
Opo. The earlier remarks made by Honorable Suntay is an appeal for objectivity, impartiality, insofar as the proceedings of the Justice Committee is concerned. Ang binanggit po niya, if we will, no offense to the most of the members of the Justice Committee, there are 25 House members named in the affidavit of the 18 ex-Marines. 25 names, which comprise around 1/3 of the membership of the Justice Committee here, all present.
The Honorable Marcoleta is likewise reminded to confine the manifestation to the relevancy of the current impeachment proceeding.
I think it's very germane, ma'am, because we will, it boils down to the objectivity and impartiality of the members.
Honorable Marcoleta, we have not reached even the determination of sufficiency, and the chair has stated already that the Justice Committee is assured of the impartiality of the chair, including all the members. I think that is premature for us to discuss on the partiality when we haven't heard any of this impeachment complaint. So unless the manifestation has relevance to the current impeachment proceeding, the Honorable Marcoleta is requested to cease from making manifestation outside the subject matter of this impeachment proceeding.
Madam Chair, with due respect to the 25 members who were mentioned in the affidavit.
Honorable Marcoleta, you're reminded by the chair already to confine to the subject matter of this impeachment proceeding. If you continue to make a manifestation outside the subject matter, we will be ruling you out of order. With all due respect, Honorable Marcoleta.
I submit to the wisdom of the chair.
Thank you. We shall now proceed to the determination of sufficiency in form. For the guidance of all the members, in determining sufficiency in form, we will following questions. Number 1, whether the impeachment complaint was signed. Number 2, whether the impeachment complaint was properly graded. Number 3, whether there was a proper endorsement by a legitimate incumbent member of the House in cases filed by citizens. Number 4, whether it was included in the order of business within 10 session days and referred to the proper committee within 3 session days. Number 5, whether the impeachment complaint is compliant with procedural and jurisdictional requirements. And last, whether the impeachment complaint complies with the one-year bar rule. We will be holding our deliberation one impeachment complaint after the other, beginning with Castro et al. Impeachment complaint, followed by Father Sabala et al. Impeachment complaint, and finally by Cabrera impeachment complaint. After all the deliberations are concluded, the justice members will be proceeding to vote again one after the other impeachment complaints.
Madam
To
Chair,
begin with,
Madam Chair,
I was about to call you Honorable Pino. What is the pleasure of the Honorable Pino?
parliamentary inquiry based on the pronouncement of the chair as to the scope of determination of sufficiency in form. In our rules, malinaw po, a verified complaint for impeachment by a member of the House or by any citizen upon a resolution of endorsement by any member hereof shall be held with the office of the Secretary General and immediately referred to the Speaker. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are correct of his personal knowledge or based on authentic records. So those are the parameters for determining sufficiency in form. My concern, Madam Chair, is that the chairman additional matters such as, for example, whether or not the filing of the complaint complies with the one-year bar. Wala naman sa explicit rules on impeachment yon. And in fact, let me note that the one-year bar applies to an impeachment proceeding, not the filing of a complaint, but the initiation of an impeachment proceeding. No, kaya po, nagtataka lang po tayo, bakit nadagdagan po ng mga kailangang i-determine ng committee ito at this point when the rules are very clear. We only have to deliberate whether or not the complaints are verified and whether endorsed by a member of the House. Madam Chair.
Before the Honorable Flores respond to the manifestation of the Honorable Tino, we would like to recognize the Honorable Micah Gonzalez, Deputy Majority Leader, the Honorable P. Bondoc from the 4th District of Pampanga, and the Honorable Ramon Rodrigo L. Gutierrez from the One Rider Party List. The Honorable Flores is recognized.
Thank you, Madam Chair. Madam Chair, tama naman po yung sinabi ni Congressman Tino na hindi siya specifically mentioned yung timeliness. But I think it should be part of the consideration in determining form, Madam Chair, kung timely nga ba yung pag-file ng isang impeachment complaint. Because it would be useless for us to consider any impeachment complaint that was filed within the one-year bar period, Madam Chair. And I think it is important that we determine it together with the other formal requirements of the impeachment complaint na dapat nga may, kung ako lang ang masunod, dapat part of the verification should include a statement that this complaint was filed na outside of the one-year bar rule if there is any. Because it would be, again, useless for us to determine the validity of the form if we know for a fact that it was filed well within the one-year bar rule, Madam Chair.
Madam Chair.
All right. The Honorable Tino.
Madam Chair, if I may, the Constitution itself says, with respect to this one-year bar, that no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. So it speaks of initiation impeachment proceedings within 1 year being barred. Proceedings. Hindi po sinabing filing of complaint. And it is very clear in our own rules and in jurisprudence jurisprudence that an impeachment proceeding is initiated not by the filing of a complaint, but by referral of plenary of complaints to the Committee on Justice. Hindi po ba malinaw yun, Madam Chair? So, kaya po, tingin ko, bakit po ginagawang issue ang hindi naman issue? The Constitution, ang pinakamataas, no? Nagsasabi, ang barred for 1 year is the initiation of an impeachment proceeding. Not the filing of a complaint. The filing of a complaint does not initiate a proceeding, Madam Chair. So, Madam Chair, please enlighten this representative kasi nga, lumalagpas po tayo sa Constitution, no? Sa nais niyong pag-include ng timeliness of filing. Wala naman pong ganong rules, Madam Chair.
The Honorable Flores is recognized.
Thank you, Madam Chair. Madam Chair, the Supreme decision noong July 25 to 2025 clearly said, no, that no new impeachment complaints, if any, may only be commenced no earlier than February 6 of 2026. That was clearly stated by the decision of the Supreme Court in July 2025. And while it may not have been stated, as correctly pointed out again by Congressman Tino, ito lang yung sinabi ng Constitution natin, but in interpreting that provision of the Constitution, the Supreme Court came out with this decision that no new complaints commenced no earlier than February 6 of 2026. And it is silent on this point on its resolution of the motion for reconsideration noong January 2026 po, Madam Chair.
The Honorable Ridon,
Madam Chair.
and then the Honorable Shua, and then the Honorable Patieros, and then the Honorable Suntay. Honorable Ridon
And
first.
Madam Chair.
Well, before proceeding further, Madam Chair, I think what the endorsers wanted to do is to matter, no? That we should not discuss it as part of sufficiency and form. But, and if this is not the situation that they want to find themselves in, I think we have to discuss it as a threshold question. And whether or not their filing is actually barred based on the Supreme Court decision and all other relevant constitutional provisions and rules of impeachment proceedings. No? So is that the pleasure of the endorsers, Madam Chair? To
May
determine this-
we request the Honorable Tino to confirm whether your concern is only to consider the compliance with 1-year bar rule as a preliminary instead of including that in the determination of sufficiency in form?
Position, Madam Chair, is that the question of timeliness is not relevant at all to these proceedings because the initiation of the impeachment proceeding is well after the so-called 1-year bar.
Nonetheless,
Based not on the original decision of Duterte versus House of Representatives, but on the ruling on the motion for reconsideration. No? So and Madam Chair, perhaps I will...
just for clarity, Honorable Tino, would you
Madam
like to discuss the 1-year prohibition period prior to our determination of sufficiency in form? Is that your pleasure?
Sabi ko, Madam Chair, na-anticipate ko na merong tutulad sa yumaong si Congressman Edsel Lagman, and they will raise a prejudicial question before the actual deliberation on sufficiency. No, I do not. I am not.
So what pleasure of the Honorable Tino?
I am merely actually, okay, if I may,
Because
I would
it is-
like to raise a point of order. Therefore, that deliberations on so-called timeliness of filing is not within the scope of this stage of the impeachment proceedings. No, because we are, as the chair mentioned herself, in the period of determination of sufficiency in form, and as our rules very clearly state, no, that consists of determining whether or not there is a complaint and whether or not this is duly endorsed by a member of the
What
House.
actually is the point of order of the Honorable Tino? Is it your intention that to actually set aside the discussion of one-year bar rule in
Yes,
relation
Madam
to
Chair.
your complaint?
Yes, Madam Chair.
Madam Chair.
Madam Chair,
The Honorable Chua first and then the Honorable Flores.
yeah, if I remember it correctly, the Honorable Tino manifested a while ago that he wanted to be clarified with respect to the word initiated. Tama po ba? Yes. Now, let me just clarify. Let me walk you through the case of Supreme Francisco versus the House of Representatives. Your Honor, Madam Chair, in that case, the Honorable Court states that the impeachment proceeding are initiated upon filing of the complaint and or resolution and its referral to the committee. Therefore, there are two acts that should be followed. First, the filing of the complaint. That's why the filing of the complaint is also necessary because that will determine a one-year bar rule. That is included in the determination of the one-year bar rule. Now, as already manifested a while ago, already expounded or explained by the Honorable Vice Chair Flores, that in the first decision of the Supreme Court, it stated expressly that no impeachment complaint should be filed earlier than February 6. And in the second decision, there is no such express statement from the Supreme Court. There is this so-called statutory construction between two conflicting laws, one express and the other one implied. The express should follow. Now, having said that, Your Honor, I believe that it is mandatory and it is necessary. We should first determine if this is filed within the one-year bar rule. Why? Otherwise, this will all be inutile, useless. If eventually this will again be used in the court to question the legality and constitutionality of this first impeachment complaint. Thank you, Madam.
Madam Chua, Chair, is it your intention to hear the discussion on one-year compliance prior to the determination of sufficiency in form?
Yes, Madam
Would you
Chair.
like to raise a motion to that effect?
Yes, I would like to move that we discuss the one-year bar rule prior to the determination of form and substance.
Motion to discuss compliance to one-year prohibition period before we proceed to the determination of sufficiency in substance. Do I hear a second? Is there any objection? Hearing none, the motion is approved. We shall now open the discussion as to the compliance to one-year prohibition, but in doing so, we will do it one complaint after the other. To start with, we are calling the endorsers of the first impeachment complaint to manifest their position with regards to their compliance to the one-year prohibition period. A quick manifestation only, because I understand that you have made ample discussions already on that in your sponsorship speech. The Honorable Ko is recognized.
Madam Chair, although Madam Chair, I'd like to clarify that in our sponsorship speeches, we have not yet taken into consideration the one-year bar rule. So I'd like to manifest and be able to provide some opportunity to explain.
Yes, please proceed.
Thank you, Madam Chair. Madam Chair, it is a position of this representation that the first impeachment complaint, Castro et al., and as endorsed by the representatives herein, respect the law that has been provided already. It is in full compliance with the Constitution and is not within and is not violative of the period of the 1-year bar. I'd like to walk through the different rules and proceedings that are applicable. Firstly, the Constitution provides the overarching framework. Article 11, Section 3, subsection 2 provides that verified impeachment, complaint for impeachment may be filed by a citizen upon a resolution and will be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. Gusto ko lang din i-point out that Article 6, Section 16, subsection 3 generally provides then the framework that each house may determine the rules of its proceedings, including the House of Representatives. That's why po may House rules tayo, may specific rules tayo on impeachment proceedings na sinusunod po natin ngayon. To supplement, Francisco of Representatives provide. It says that the initiation takes place by the act of filing and referral or endorsement of the impeachment complaint to the House Committee on Justice, etc. So also in the argument by the Honorable Representative Joel Show earlier, which says that there are two acts, filing and referral. That's true. Pero kung titignan din naman natin sa praktikalidad, titignan natin yung date, ano ba yung material date dito? It is the referral. Dito po, here and in other instances, tinitignan kung kailan po nagkaroon ng pagsisimula ng 1-year bar period. And so according to Francisco, sa pag-alam kung kailan magsisimula ang 1-year bar, the date is referral date. Dinigagan naman po ito ng Duterte versus House of Representatives just this January 2026. Ni-reaffirm niya ang Francisco versus House of Representatives and ruled further. Meron pong 2 other instances kung saan may, for the purposes of initiation of the 1-year bar, kinonsider. Yung una, yung discuss na sa Francisco, yung referral to the Committee on Justice. And I am putting here the 4th point of the Duterte versus House of Representatives of 2026, pages 4 and 40. Number 1, referral to the Committee on Justice. Number 2, it is properly verified and endorsed by a member, and it is not put in the order of business or referred to the proper committee within the constitutional periods. Number 3, properly verified and endorsed siya or properly referred to the committee but has not been acted upon by the House upon its adjournment sine die. So, kung may filing na pero hindi nasunod ang constitutional dates na dapat nasa order of business na within 10 session days o page 30 provides that the respondent house had until January 14, 2025 to include the complaints in the order of business and until January 21 to refer to the proper committee. I'm talking about po yung 19th Congress impeachment proceedings. Kung nalagay pa ito sa order of business noong January 13 or 14, yun po yung limit, hindi po sana matitrigger yung B kasi magiging proper yung referral. Pero hindi ito nangyari. Nangyari lang po ito noong February 5, 2025. Kaya starting January 15, 2025, batay sa desisyon ng Korte Suprema sa Duterte versus House of Representatives, compliant with the constitutional periods ang impeachment proceedings, thus triggering the 1-year bar rule. Dahil po dito, Madam Chair, na-observe natin itong 1-year bar period. And then, February 2, 2026, final ang Castro et al. Complaint. 1 year and 18 days after January 14, 2025. Ang 10th session day matapos ang filing ng impeachment, first impeachment noong December 2, 2024. So therefore, hindi po ito barred. Nirefer naman ang mga impeachment kong February 23, 1 year and 27 days after January 14, well beyond at lagpas na sa period of the 1-year bar. It also bears mentioning na pasok ito sa constitutional periods. The first filing was on February 2, and 8 session days after, on February 23, pinasok ito sa order of business at refer sa House Committee on Justice. And also, responding to the earlier argument that they may specific citing of a date in the Duterte versus House of Representatives 2025 decision, and then na silent po ito sa 2026 decision. If we look at kung ano yung nakalagay po doon sa pag-rationalize, ano na yung bagong impeachment, ano na yung bagong rules sa bar na i-observe serve or sa period ng 1-year bar, no, ito po ay overturned. So I'd like to emphasize, no, we are in the ambit of essentially letter A of the Duterte versus House of Representatives now. No, and yung filing po ng 19th Congress falls under letter B. No? And ang pertinent date po doon is yung start na hindi po nasunod yung constitutional period of the order of business sa pagpasok ng order of business, which is on January 14. And therefore, since na-file po ito on February 2 and na-refer to the Committee on Justice and na-pass sa order of business, itong impeachment proceedings on February 23, now this is all beyond the 1-year bar period. And I'd like to make a last manifestation, Madam Chair. No? Isipin ng napakarami ng mga teknikalidad ng tong mga to. For us, no, these aren't mere technicalities. This discussion is political in the most fundamental sense of the word. It goes into the heart not only of the impeachment process, but the balance of powers this republic is built upon. It will determine how the legislative branch will stand on its authority as a separate branch of power now and in the future whenever this can come into question. No, kapag tayo, nakita naman natin at tumitindig tayo na this is all initiated and the proceedings are conducted well beyond the 1-year bar period, no, hindi po dapat tayo matakot sa any form, no, of suit na maaaring i-file against the House of Representatives dahil tayo ay nag-comply naman sa mga rules and regulations, hindi lang po na sinet dito sa House, but also under the Constitution. That's all, Madam Chair. Thank you very much.
Thank you. I understand that the position of the endorser, Honorable Ko, is very comprehensive. So may I manifest that the same is adopted already as the position of the two other endorsers. No?
Madam Chair.
At this juncture, we would like to recognize Honorable Chua and then Honorable Rodriguez and then Honorable Sunta.
Thank you, Madam Chair. Thank you, Madam. Just a quick manifestation, Madam Chair. Hindi naman po tayo natatakot. We would just like to exercise circumspection. So lamang po natin mag-ingat. Less, ganun naman po mangyayari after what happened in the last impeachment complaint. Baka mamaya, wala na naman po mangyayari dito by sheer technicality. Now, having said that, Madam Chair, when we interpret the decision of the Supreme Court in Francisco, we should interpret it as a whole by including the filing. Hindi naman po sinabi dito na or eh. Ang sinasabi dito, filing and referral. So when ibig sabihin po yun, one, hindi po natin po pwedeng i-consider yung isa nang wala po yung isa. So dapat po yan, pag kinu-consider po ninyo, para po yung kambal. Lagi po yung magkasama. Yun lamang po, Madam Chair.
Thank you. Next is the Honorable Rodriguez.
Thank you, Madam Chair.
The Honorable Erice will be called after the Honorable Flores. Honorable Flores is number 6. But before we proceed, just for the guidance of everyone, the first impeachment complaint was filed on February 2. That is prior to the February 6 allowable date of filing as expressly pronounced in the decision of the Supreme Court dated July 25, 2025. The issue, therefore, which we are deliberating upon is whether or not the first impeachment complaint is in compliance with the 1-year prohibition period. The Honorable Rodriguez, you may proceed.
Madam Chair, the 4 pertinent dates on the impeachment complaint in 2025. It's first February 2, the first impeachment complaint. December 2. Next, December 4. Next, December 19. Supreme Court decides February 6. However, Madam Chair, in that motion for considerations which we have read, clearly, that particular February 6 had been modified because a later decision like an M will therefore be able to amend and
whatever has been stated if it's in conflict with the recent decision, and that is the motion for reconsideration. And therefore, in this case, having read the decision stated by the Honorable Ranny, that there was a problem in the 19th Congress because there was no referral and the following of the constitutional provisions and the cases and the case of Francisco versus House of Representatives. So therefore, in that particular case, the Supreme Court in fact said that the impeachment, the dates that are in the Constitution should not be session days but calendar days. Well, in that case, Madam Chair, it is also an overreach because by December 19, we're having a break. So we are right here right now considering that we should only count session days. We will not be calendar. Otherwise, if that was the case, we will therefore there's no more chance to be able to refer that. But the situation is, I may not agree with January 15, but if you will compute when you resume, considering that there will be 10 days, then the period will end in the last week of January if you count on calendar, on session days. Therefore, the filing on February 2 is within the time after the 1-year bar. So it has elapsed either February 15 or January 30. February 2 is therefore a correct timing to file the decision, to file the complaint. Therefore, on the issue of threshold, Congressman Ridon is correct. This is a threshold issue because the Constitution and the jurisprudence on Francisco and in our rules, because that is the Constitution, the highest fundamental law of the land and highest court. And so therefore, Madam Chair, clearly the February 2 filing is within the constitutional provisions. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. Next in line is the Honorable Suntay.
Thank you, Madam Chair. Well, I would like to agree with the opinion of Vice Congressman Chua and our Vice Chair, Congressman Flores. Initiation and commencement are an impeachment complaint is commenced by the filing of the complaint. Kung wala yung complaint, there is nothing to commence. Under the ruling of Francisco, initiation is a two-step process. First, the filing, and then the refer to the Committee on Justice. The 2025 decision was very clear. No impeachment proceeding may be commenced. Commenced yung ginamit na salita, hindi initiated. So, what is commenced? As I mentioned earlier, the filing of the complaint commences the impeachment proceeding. So, very clear then that no impeachment proceeding may be commenced prior to Feb 6. Meaning to say, yung Feb 2 was clearly filed out of within the 1-year bar period. Now, assuming na hindi natin yung 26, kasi alam mo, yung 25 ruling was very specific. Yung 26 ruling was silent on this matter. So, as we all know, ang controlling yan is yung specific. If there was a specific date na binigay. Now, assuming na yung initiation yung pinagkabasihan natin, shouldn't the two-step process also be with outside the 1-year period? Kasi ang mangyayari para bang manananggal yan, yung initiation, yung filing ng complaint, pasok sa 1 year, pero yung referral labas sa 1 year. So, ano yung magiging decision? I agree with Congressman Chua, hindi naman natin count na maaaring sufficient informed, pero dapat pag-usapan kasi baka masayang. Baka later on, itatakbo sa Supreme Court, at sasabihin sa Supreme Court, barred yan eh. Then, everything that we're doing here would be for now. Thank you, Madam Chair.
Thank you, Honorable Suntay. Next is the Honorable Suwan.
Madam Chair, I agree with the position of Congressman Bong Suntay because the Supreme Court in its decision on July 25, 2025 was very clear. It held that no new impeachment against the respondent, if any, may be commenced. The word was commenced no earlier than February 6, 2026. The Supreme Court did not speak casually. It was construing Article 11, Section 3, subsection 5, which provides in unmistakable language, no impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. So, if a complaint was filed on February 2, 2026, 4 days prior to February 6, 2026, then we must confront a fundamental question. Are we within the constitutional window? Because, Madam Chair, if we are not, then this committee risks proceeding without constitutional footing. Madam Chair, it is important to answer this question because the 1-year bar was deliberately placed by the framers to prevent impeachment from becoming a weapon of constant political siege. In fact, it exists to protect the stability of governance regardless of who occupies the office. The 1-year prohibition, therefore, is a constitutional shield, not a technical obstacle. Madam Chair, this is not about shielding any individual from accountability. It is about ensuring that when accountability is pursued, it is done within the exact bounds of the Constitution.
Thank you, Honorable Suwan. Next is the Honorable Redon.
Madam Chair, I think we need to
Is
restate.
your position?
We have to restate what had been said by the Supreme Court in the resolution itself. In the Duterte versus House of Representatives, and I will quote it. Fourth, complaints based on the first mode or Article 11, Section 3(2) is deemed to have been initiated for purposes of the 1-year bar under Section 3(5) when A, it is referred to the Committee on Justice, B, it is properly verified and endorsed by a member of the House of Representatives, and it is not put in order of business or referred to the proper committee within the constitutional periods, and C, it is properly verified and endorsed and properly referred to the proper committee but has not been acted upon its adjournment sine die. It needs to be stated, Madam Chair, that the first impeachment complaint against the Vice President was filed on 2 February 2026 and was just transmitted to the Office of the Speaker on Feb 5/6 without referral to the Committee on Justice yet. The referral to the committee was done on 23 Feb 2026, and as such, the first impeachment complaint against the Vice President should not technically be included by the 1-year bar, as it was filed only prior to 6 Feb 2026 and not initiated prior thereto. And more importantly, an argument may be made that because of the Supreme Court resolution, the amendment of the definition of the term session days had basically redefined the periods for initiation, Madam Chair. But frankly, the committee will have to contend with the question on what the Supreme Court decision actually stated expressly, which was no impeachment complaints may be referred on Feb 6, 2026. Madam Chair.
Thank you. Next is the Honorable Flores.
Thank you, Madam Chair. Madam Chair, again, i-emphasize ko lang po ito, no, na sa decision ng Supreme Court noong July of 2025, it mentioned the date 3 times. First, on the adjudicative rulings on page 6. Second, in the summary on page 94 of the decision. And third, in this positive portion on page 95 of the decision. So, klaro po na sinabi nila na walang pwede ma-comments prior to February 6 of 2026, Madam Chair. So, what it may be implied, because nga sa resolution is iba din yung computation nila sa session days, pero obvious naman po in rules of statutory construction na what is implied is cannot overturn what is expressed. Sabi na is what is expressed put an end to what is implied, or a person omitted must have been omitted intentionally. Kasi walang mention po ito sa resolution ng motion for reconsideration, Madam Chair. So with that, Madam Chair, I move that we set aside the first complaint because it was filed prior to the lapse of the one-year bar rule, Madam Chair. I so move.
I object.
I object.
Before we act on the motion and on your objection, Honorable Elise would like to manifest as well.
Yes, Madam Chair. It's kind of tricky because in the Constitution, the initiation is the process when you file it, and then the Speaker prepare it to the Committee on Justice. That's the Constitution. Kailangan pong ma-repair sa Committee on Justice. Yan po yung initiation. Meron pong ruling ang Supreme Court na February 6. Maliwanag din po yun. Pero nakikita po akong malaking problema. Sapagkat kung may one-year bar rule at naniniwala tayo na February 6 ang one-year bar ang dapat na sunding petsa, bakit tinanggap yung complaint ng Office of the Secretary General? At bakit ito ni-refer ng Speaker sa Committee on Justice? Ibig po bang sabihin in the next few days, pwedeng mag-file ng complaint every day for the next 300 days? Tatanggapin pa rin ng committee ng Office of the Secretary General at i-refer pa rin ng Speaker sa Committee on Justice, at ang Committee on Justice ang mag-decide whether the complaint is within the one-year bar rule. Yan po yung tricky question na siguro natin pag-isipan.
Let us be reminded that the duty of the Office of the Secretary General to receive the impeachment complaint is ministerial. They cannot actually refuse to accept impeachment complaints which are being filed. And that is why it is incumbent upon us, the Justice Committee, to dispose of the issue of whether or not the impeachment complaints were filed, whether in compliance or in violation of the one-year prohibition period. The same is true with respect to the duty of the Office of the Speaker to include the same in the order of business within the period of 10 days from the date of transmittal. And the same is true as well with respect to the plenary in referring the same to the Justice Committee. Honorable Elise.
Meaning, Madam Chair, that anyone can file a complaint every day in the next 300 days. And it will be accepted by the Office of the Secretary General, and it will be referred to the Committee on Justice. That will be the rule now.
Yes, Honorable Elise.
Thank you.
And we are in the best position actually to address this issue of whether or not there is a violation or there is a compliance with the one-year prohibition period. Before I call you Honorable Tino, next in line is the Honorable De Lima. We are reminding the Justice members that there is a pending motion already raised by the Honorable Flores. The same has been seconded. We will just be finishing those who raise their hands for the manifestation. And I believe that Honorable De Lima is the last in this line.
Thank you, Madam Chair. I objected to the motion. This representation objected to the motion, and I'm compelled to also share my thoughts and share my views on this matter, considering that if we are to apply the contention of some of our members here about questioning the timeliness that is still barred within the one-year bar rule, the filing of the first, and that also included the filing of the second, which was subsequently withdrawn. And as an endorser of the second complaint, I've always taken the position that the filing on February 2 was timely. It's within the constitutional deadlines, and it did not violate the one-year bar rule. So, since ang pinagtatalunan po natin dito, kailan ba talaga? Is it February 6? Kasi sa una kasi, in the January 26 decision, it says the earlier July 2025 ruling's point of reckoning shifts from February 6. It has to be on February 6. Yun po ang nakasabi explicitly doon sa first or sa main decision. But did the January 28, 26 decision move the one-year bar? My position is yes, in effect. It may not have been as explicitly stated in the discussion about the one-year bar rule, but it is clear to me na ganun po ang epekto. Bakit po? Iniba po kasi nila yung interpretation ng session days. Whereas before, it was supposed to follow our legislative interpretation, not necessarily calendar days, kundi yung kung kailan talaga yung kailan yung adjournment nung a certain session, and then it will be resumed again in another new session day. So it does not necessarily cover or involve a calendar day. But in the February 28, 2026 resolution denying the MR, naiba na po. So dahil nga dun sa iniba nila yung definition ng session days as calendar days, so the House is actually in session. The Supreme Court, in effect, or actually recalibrated the point. 1-year clock begins. So under the definition, the earlier July 2025 ruling's point of reckoning shifts from February 6 to January 21. Bakit ho January 21? Kasi ito po yung referral to the committee. The filing was earlier. If I'm not mistaken, was it January 14? No, January 14 is the inclusion in the order of business. But the referral was in January 21. So, session days as calendar days when the House is in session, the one-year bar rule, the one-year bar would expire by January 21. Therefore, the earliest that a new impeachment complaint against VP Sara Duterte can be filed with the House is January 21, 2026. Hindi po kasalanan ng mga complainants na they relied on the latest redefinition, reinterpretation by the Supreme Court, which was also made the basis of denying the motion for reconsideration. It's fundamentally unfair na kung i-apply pa rin natin, ang i-insist pa rin natin is the original date of February 6. It has been moved because it's the Supreme Court itself that recalibrated everything about the definition of session days. Napaaga yung reckoning point. So why fault the complainants by saying that is now violative of the one-year bar rule, and that is not their definition initially, but they had to follow. They followed the court. They complied with the constitutional timeline as interpreted by the court. They acted in good faith, definitely. Walang masama sa pagsunod sa pinakahuling interpretasyon or interpretative ruling o doktrina ng Korte Suprema. So I agree with both the Honorable Representative Rufus Rodriguez and also the Honorable Representative Teddy Lidon that it should not be January 6, but the earlier date as a result, a necessary consequence of the Supreme Court's definition and recalibration of what the session days actually mean. We may not agree, I myself do not agree, but we have to follow that because that is the latest interpretative ruling, as I said, it would be fundamentally unfair for the complainants of the first. Kung nandito pa nga po yung second complaint, kung hindi pa na-withdraw, I will still be taking that position. Maraming salamat po.
Okay,
Chair.
our parliamentary
Madam Chair.
status is there is a motion
Yes.
to set aside the first
First complaint.
impeachment in view of the violation of the one-year prohibition period, and we have expressed our positions on the matter.
Madam Chair,
Meantime, we will be suspending for 2 minutes. The meeting is resumed. Our parliamentary status. There is a motion to set aside the first impeachment complaint, that is Castro et al. Impeachment complaint, in view or on the ground of violation of the one-year prohibition period. The same has been seconded and the same has been objected to. Before we vote on the motion, we will hear additional manifestation from the Honorable Pino.
thank you, Madam Chair. Of course, bilang endorser, I vehemently object to the motion to set aside the complaint that we endorsed on the issue of allegedly that the complaint was filed in violation of the one-year bar rule. Madam Chair, sa motion ni kagalang-galang na Kit ay binanggit po na tama, no, sinite niya at nakatungtong ang kanyang objection sa naunang ruling ng Supreme Court in Duterte versus House of Representatives. At sabi niya, 3 beses nga daw binanggit sa decision na yon yung February 6, 2026 deadline, no, for the one-year bar, no. Let me cite just the third and last instance. Let me quote the third and last where that decision mentioned that date. Sabi rito, new impeachment complaints against the respondent, if any, may only be commenced no earlier than February 6, 2026. Let me emphasize the word used by the Supreme Court. May only be commenced. No? So ang punto po natin dito ay gumagamit ng bagong lengguwahe ang Supreme Court. No? The one-year bar rule, as we established in the Constitution, speaks about initiation of impeachment proceedings. Yun po ang pinagbabawal. Ngayon, may bagong formulasyon ng Korte Suprema. Sinasabi niya, new impeachment, new complaint may only be commenced. No, so bagong, in effect, this is a new rule, no, na with respect to when an impeachment complaint may be filed in a timely manner. Meron na pong konsepto ng commencement. Sa rules po ng House, no, wala pong anumang pagbanggit sa issue ng commencement. No? Kaya po, tingin na hindi po nag-apply ang ruling na ito sa proceedings ng House on impeachment. Ang gusto ko lang pong ipanawagan sa komite at sa buong House, no, ay malinaw na separate and co-equal branch of government ang Kongreso at in particular sa House of Representatives nakakargo ang impeachment bilang pinakamataas na proseso ng pagpapanagot sa mga pinakamataas na opisyal, no? Kanina sinabi po ni Representative Chua, mag-ingat na lang tayo, baka mamaya kapag inalaw natin ang first complaint ay dali na naman ito sa Korte Suprema at baka mabasura pa, no? Ang hamon ko po at panawagan sa committee at sa buong House ay huwag po tayong matakot sa sarili nating anino. Panghawakan po natin ang sariling rules ng House on impeachment. Tayo po ang institusyong ito, no, ang House of Representatives ang gumagawa ng sariling rules on impeachment at ang tanging may kakayahang matupad ng rules na ito. No? Sa rules natin, walang usapin ng commencement. Kahit pa sabihin yan ng Supreme Court. No? Bakit importante po ito? Hindi lang po ito technicalidad. No? Dahil kung hindi ito gagawin ng House, kung hindi panghahawakan, if we do not take ownership of our own rules and impeachment, at every step, kahit sinong gustong hadlangan ng pagpapanagot, ikalawang pinakamataas na opisyal o sino bang impeachable official, at any point pwede pong tumakbo sa Supreme Court para questionin ang rules natin. No? Katulad na nga nung nangyari sa nakaraan. So therefore, mga punto natin, kailangang panghawakan ng House ang sarili niyang rules on impeachment. Dahil sa tanging sa pamamagitan niyan, maaaring magtuloy-tuloy ang impeachment, panagot ang mga pinakamataas na opisyal na walang takot na ibabasura ito because of some new rule that the Supreme Court may come up with, Mr. Speaker, Madam Chair. So kaya po, muli, I vehemently object to the motion and the House to take ownership of its own rules on impeachment and to really fulfill its constitutional duty of impeachment. Maraming salamat po, Madam Chair.
Again, for the guidance of the Justice members, we are deliberating on the compliance or violation of the first impeachment complaint with regards to the one-year bar rule. We will reiterate that the first impeachment complaint was filed on February 2, 2026. And we are in between two decisions of the Supreme Court, the July 2025 decision, which expressly provides for February 6 as to when there can be the filing of the second impeachment complaint, vis-a-vis the resolution of the Supreme Court on our motion for reconsideration that is dated January 28, 2026, which by implication provides that the 10-year period lapse last January 14 of 2026. So in view of these two decisions, the original decision and the recent resolution, we have disparity with respect to our positions on whether or not the first impeachment complaint indeed comply or violated the one-year prohibition period. And with that, I hope the justice members are properly guided with all the meaningful discussions that we have heard, members of the Justice Committee. Soon we will be voting, but before we proceed to that, will the endorser wish to say something about the compliance to one-year prohibition?
Yes, Madam Chair. ang
Yes, you may proceed,
representasyon
Honorable
na-
Ilago.
Yes, ang representasyon na ito ay isa rin sa mariin na tumututol sa motion na iset aside ang verified impeachment complaint na ating na-endorso. Matagal nang naghintay ang mga complainants. Marami ho dito ay kabilang din sa mga nag-file ng impeachment complaint batay sa betrayal of pabas noon pang nakaraang taon. Sila ho ay tagal na naghintay at matagal din na nagtitiis doon sa mga opisyal na pilit na tumatakas sa pananagutan. Dahil ho sa kanilang paninindigan, sila rin ay masusi na nag-aral noong naunang desisyon ng Korte Suprema hanggang doon sa motion for consideration, hanggang doon sa pinakahuling desisyon na nag-move nitong one-year bar rule. Kaya ho, isang malaking inhustisya ang hindi paninindigan ng House of Representatives sa sarili ng mga rules, sa sarili nitong mga proseso, pagdating sa paghahandle ng ganitong tipo ng napakahalagang mga proseso para sa transparency, para sa accountability at pagtitiyak na ang bawat piso ng pondo ng ating bayan ay nagagastos talaga para sa kapakinabangan, para sa pangailangan ng tao. Kaya Madam Chair, isa rin ho tayo sa mga nakikiusap, nananawagan, na huwag tayong mga members tayo ay manindigan at panghawakan natin ang ating sariling House rules pagdating sa pag-handle ng mga impeachment proceedings at makita at marinig masama ang lahat ng mga complaints sa didinggin ng komite na ito. Maraming salamat.
We've heard already the three endorsers of the first impeachment complaint.
Just a quick manifestation.
Honorable Chua, I hope you will be the last because we think to vote. Honorable Nasal, would you like to say something also?
Yes, Madam Chair. I would-
Okay, so Honorable Chua and then Honorable Nasal and then Honorable Digamo and then we will vote already.
Thank you, Madam Chair. Madam Chair, hindi po tayo natatakot dito sa committee ito. Because the reason why we are trying to be careful with the interpretation of the Supreme Court decisions is because this is an issue of jurisdiction. Jurisdictional issue po to, which is very important. So, yun lang po. But of course, I hope the endorsers understand na we are not against them. Ito lamang pong iniusapan because as already stated, lahat naman po during the past impeachment, the House did its homework and in fact, we followed what is under the rules of the House. But the House is not the problem. It is the other department. No, the interpretation of the other department. And in fact, it was used when the impeachment complaint was forwarded to the Senate. It was used. The issue was used. So, yun lang po. Hindi lang, kaya that's why we are trying to be careful. Thank you po.
I hope that the endorsers are listening to Kong Joel, he's saying that all of you are his friends. And he is not against you. He was just traumatized by what happened to the first impeachment process. That's what he's saying. Okay, so moving forward, we would like to recognize Honorable Nasal.
Madam Chair, kaya po kanina, for my earlier manifestation, kaya
Yeah, I
sinasabi
remember
ko
it's about a year.
na sana po ma-resolve na even before magkaroon po ng question on
Our perceived inconsistency of the original decision vis-a-vis the resolution is not for us to resolve really, but it is for the branch of government which issued the same. The least we can do at this point in time is to be very cautious as we conduct this impeachment proceeding.
Thank you, Madam Chair.
The Honorable Degamo.
Madam Chair, last before after. Madam Chair.
You've said a lot already, Honorable Ko. After Honorable Degamo, we shall proceed to vote.
That is correct po. I agree with the explanation of our fellow members of Congress. But there's also one reason I would like to add why I believe that we have to proceed with tackling the other issues or other complaints. It's because of the discrepancy too of the signature in the affidavit of the first complaint. If you are to look at the signature there, the one in the, how do you call this, affidavit is different from the passport that is being presented as an ID, no? Or a so parang the more I'm resolved to vote against taking into consideration the first complaint.
The manifestation of the Honorable Degamo is noted. Now we shall proceed to vote. Again, our Parliament has, there is a pending motion to declare, to set aside the first impeachment complaint, that is Castro et al. Impeachment complaint on the ground of violation of 1-year prohibition period. The same has been objected to as well, and we shall now proceed to divide the House. Those who are in favor of the motion, please raise your right hand. You may now put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hands. Last, those who abstain, please raise your right hand. Secretariat, the result of the voting, please. With 22 votes in the affirmative and 10 votes in the negative, with 0 abstention, the chair set aside impeachment complaint, the Castro et al. Impeachment complaint on the ground of violation of 1-year prohibition period. So ruled.
Chair.
The Honorable Ko.
Point of clarification only.
Come again?
A point of clarification.
What is your point of clarification?
Can this representation clarify what the meaning of set aside is? Ano po ba yung legal effect nito dito sa buong proceedings?
By set aside, it means that it will no longer be included in the proceeding of this committee. With all due respect to the endorsers of the first impeachment complaints, of course, I wish to state for the record that I think all our endorsers are members and ex-officio members of the Justice Committee, and we encourage all of you to continue actively participating in the deliberation, endorser, then as esteemed members of the Justice Committee.
Thank you, Chair.
That is for the record. We shall now proceed to our determination in form because of the withdrawal of the second impeachment complaint and the setting aside of the first impeachment complaint. It now appears that there are only 2 impeachment complaints. The third and the fourth. The third is the Reverend Father Sabah impeachment complaint, and the fourth is the Cabrera impeachment complaint. We are now proceeding to the determination of sufficiency in form. May we request the endorser of the third impeachment complaint to make a quick manifestation as to her position with respect to the third impeachment complaint in form.
Thank you, Madam Chair. As a quick manifestation on the issue of the determination sufficiency in form of the third complaint that I endorsed, I strongly manifest that the verified impeachment complaint filed by Reverend Father Sabali et al. And duly endorsed with his representation is sufficient in form. In fact, more than sufficient in form. Naniniwala po ako na dun sa Gutierrez versus House Committee on Justice, GR number 1934559, February 15 to 11, ang sabi ng Supreme Court, the House has formulated determinable standards as to the form and substance of an impeachment. It further says, impeachment rules are clear in echoing the constitutional requirements and providing that there must be a verified complaint or resolution. There is a verified complaint, duly signed and dated. It was filed through counsel or assisted by counsel, the Sapayan, Lim, Alvarez, and Ligutan, or sa legal law offices, and complainants are members of the clergy, priests, pastors, and nuns, members of the bar, and members of NGOs. They are residents of various localities in the Philippines. The complaint was filed last February 9, 2026. No issue on whether or not there is violation of the one-year bar rule because it was filed February 9 or after February 6. Nung final po, nung February 9, itong third complaint, dun sa araw na yon, the first 2 impeachment complaints, the second nga po ay na-withdraw na ngayon, on February 2, were not yet included in the order of business. By February 9, 2026, only 3 session days elapsed. So, complainants filed the third impeachment complaint within the 10 session day requirement as interpreted by the Constitution. Na, it's not really the session days that we are used to adopting, but the calendar day where session is held. On February 23 po, yung pag-include sa order of business. So, the Speaker did so within 10 session days of the February 2 session, the February 2 session. On the same date, the House referred all the impeachment complaints to the Committee on Justice. Their referral was also well within the 3-day session requirement under the Constitution. Verification, the requirement of verification, it squarely complies. Nakalakip sa complaint ang individual separate verifications and certifications of non-forum shopping of each of the things. Hindi po ito joint verification but individual. Kung saan malinaw na pinahayag under oath ng mga complainants na kanilang nabasa ang complaint at ang mga aligasyon ay totoo at pasto batay sa kanilang personal knowledge o sa authentic records. Ito ay pirmado at sinumpaan sa harap ng iba't ibang notary public dahil nga po galing sa iba-ibang lugar yung complainants. Yung endorsement, wala rin pong problema. It's here, the resolution endorsing the impeachment complaint. This is on the top of the complaint annexes. So kung ang tanong ay nasunod ba ng complaint na ito, mga formal requirements, alinsunod naman sa Constitution at sa rules, ang sagot po ay oo. Thank you very much.
Thank you, Honorable De Lima. Now we're opening the floor for comments and manifestation of the justice members.
Madam Chair.
The Honorable Ann Matibag.
Madam Chair, I would like to agree with our Honorable Senator Leila De Lima that the complainant is signed and verified by the complainant, Reverend Father Joel Sabale et al. And attached to the complaint, Madam Chair, are the verifications of the complainant.
All right. Any other member who wishes to manifest their comment as to the sufficiency in form of the third impeachment complaint, that is Abalia et al. Impeachment complaint?
Madam Chair.
The Honorable Franz Legaspi.
Thank you, Madam Chair. Just a quick manifestation as well, just to support my colleague, Kong Ann Matibag, and of course to Kong. I think it's quite clear to everyone here that the form is sufficient in the sense that it complied with the verification requirement, it complied with the rules that we have, specifically Section 2, Section 3 of Rule 2 of the impeachment proceedings. Particularly upon reviewing the complaint earlier, it's clear it fulfilled the requisites. Basically, the affiants are the complainants, the affiants had read and understood the complaint, that more importantly, that they are based on the true and personal knowledge or authentic records and documents. So aside from that, I also like to highlight that there's compliance by the clergy and the other people's organizations here, and that this complaint clearly, as mentioned by Kong Laila earlier, was properly endorsed by her office by a resolution as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. Any other Honorable
Madam Chair.
Chua?
Thank you, Madam Chair. Madam Chair, I would like to share the observation of the endorser, the Honorable Laila De Lima, that the third impeachment complaint has faithfully complied with the Supreme Court's ruling and the pronouncement on impeachment. I totally agree that it is within the period as provided, and in fact, it was filed on February 9. It was included in the order of business on February 23, and on the same day, it was also referred to the Committee on Justice within the time frame as provided by the Constitution, by the rules, and by the Supreme Court's decision. Thus, it is my view that the third impeachment complaint complies with the jurisdictional requirement when it comes to the issue on one-year bar rule. And hence, it is timely filed.
Just wish to state for the record that the third impeachment complaint was filed on February 9, 2026, and then was included in the order of business and referred to this committee on February 23, 2026. That is for the record. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Well, I fully support as far as that issue is concerned. I have a point of inquiry. What is the complaint which we had just previously dismissed on this third and fourth complaint? Look, we said that's the decision of this committee. It was filed within the prohibited period of 1 year, but it was referred to by by this committee, and this committee had decided that it was within the 1-year bar rule, so we did not consider it. What will be its effect? Will it bar this third and fourth complaint?
The Honorable Dumogan understand that the issue with respect to the first impeachment complaint has been resolved already.
Yes, and what is the effect of the decision of this committee not to consider it, because it is within.
The only consequence of that ruling, Honorable Vice Chair, is for us to be able to proceed with the third and fourth impeachment, and we will not be including anymore in our deliberation the first impeachment complaint. That is the consequence of the ruling of the motion.
I am worried on that ruling. Anyway, it's my view. I'm really worried on that ruling. Thank
Madam
you.
Chair.
The Honorable Dilemma.
To add a point, whether it was the earlier period, which is
January 14.
January 14 or 21, because 21 is the referral, or the February 6, which is the one stated in the main decision. This does not violate, the third complaint did not at all, or does not violate the 1-year bar rule, since yung pinakauna na mga na-file too. And therefore, doon nga tayo nag-count ng 10 session days and 3 session days thereafter. So no problem at all, no effect on the third and even the fourth complaint.
Yes, that is correct. We totally agree to that. That whether we consider the January 14 as the lapse of the 1-year prohibition period or the February 5 to make it possible for the second impeachment on February 6, the third impeachment completely falls within the allowable period in both dates as perspective. If there are no other members who wish to comment on the in form of the third impeachment complaint, we shall proceed to hear the position of the endorser of the fourth impeachment complaint. No more members? We recognize the Honorable Deputy Speaker Paulo Ortega to manifest his position with respect to the sufficiency in form of the fourth impeachment complaint, that is Cabrera impeachment complaint.
Thank you, Madam Chair. Maikli lang po, would like to manifest that in terms of form and requirement, the fourth impeachment complaint has complied in terms of form, and we have endorsed it on the date February 18, 2026. Thank you, Madam Chair.
Thank you. Now we're opening the floor for comments and manifestations of the justice members with respect to the sufficiency in form of the fourth impeachment complaint. The Honorable Zamora is recognized.
Thank you, Madam Chair. As regards the fourth complaint, the complainant, a certain attorney Nathaniel G. Cabrera, signed the same and also executed a verification which states as follows: the allegations in the complaint are true and correct based on my personal knowledge or based on authentics. The verification was signed and notarized on February 18 in Quezon City and was notarized by a certain attorney Jason San Buenaventura. The resolution of endorsement by Representatives Benvenido M. Abante Jr. and Representative Francisco Paulo B. Ortega V was signed February 18, 2026. Both of them subscribed and swore before the Secretary General on even date. So, Madam Chair, we believe that the fourth impeachment complaint is compliant with the requirements of sufficiency of form. Thank you.
Any other member who wish to comment on the sufficiency in form of the fourth impeachment complaint? No more? Can we proceed to vote now? As agreed upon at the onset, after we conclude on the deliberation on all the impeachment complaints, which at this point we only have two, the third and the fourth impeachment complaint, we proceed to vote. The chair is now ready to hear the motion with respect to the sufficiency or insufficiency in form of the third impeachment complaint.
Madam Chair.
The Honorable Zamora.
Madam Chair, I move to declare the third impeachment complaint as sufficient in form.
There is a motion to declare the third impeachment complaint sufficient in form. Do I hear a second? Is there any objection? Hearing none, the chair declares the third impeachment complaint, that is Father Sabalia et al. Impeachment complaint, sufficient in rule. The chair is now ready to hear the motion on the fourth impeachment complaint. The Honorable Padiernos.
Madam Chair, I move to declare the fourth impeachment complaint as sufficient in form.
There is a motion to declare the fourth impeachment complaint, that is Cabron complaint, sufficient in form. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the chair declares the fourth impeachment complaint, that is Cabrera impeachment complaint, sufficient in form. So ruled.
Madam Chair,
The Honorable Marcoleta.
point of order. This is not directed to the members of the committee.
Madam Chair, our good friend is not a member of the committee.
Yeah, but I can.
Perhaps
Raise a
you
point
can
of
just
order.
manifest
Or just
instead of raising a
manifestation.
point of order.
Manifestation.
All
Not
right,
directed.
you may proceed, Honorable Marcoleta.
This is not directed to the members of the Justice Committee, but I observed the presence of Mr. Kikudi from the audience, allowed to be an audience in the proceedings, despite his withdrawal of the second impeachment complaint. I suggest that he observe proper decorum, because if you remember,
May we know the action of the Honorable D or Mr. D, which is not consistent with decorum?
I'm just speaking from experience when the
Which means he hasn't committed any yet.
not yet, but as a forewarn, as a premonition or a warning, he during the archiving of the impeachment at the Senate,
Madam Chair,
Mr.
Madam
D,
Chair, wala pa naman palang ginagawa. Let us not...
Point of order. Let's wait until he finishes, and then I will
just
be
allow me to
recognizing him.
finish. During the archiving of the impeachment, Mr. D booed and made a gesture of thumbs down at the VIP gallery of the Senate.
All right. All right. Honorable Marcoleta, but it is apparent
Subject to
that
proper decorum.
the Honorable D hasn't committed anything yet, which is not consistent to decorum. Would you like to say something, Honorable De Lima?
Yes, Madam Chair, it is completely improper for our colleague here to raise that matter. And he has not cited any act of misbehavior on the part of Mr. Kiko D. And alluding...
Would you like to make a motion to that effect?
Yes, my motion is to strike out the manifestation.
Second, Madam Chair, there is a motion out from the record of manifestation of the Honorable Marcoleta. The same has been seconded. Is there any objection? Hearing none, the motion is granted. The manifestation of the Honorable Ma is hereby ordered stricken out of the record. If there are no other matters which the members wishes to discuss, the chair is ready to hear your most favorite motion.
Move to adjourn, Madam Chair.
There's a motion to adjourn. The same has been seconded. No objection. Our meeting ended until tomorrow